Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're talking about a recent legal battle over a law passed by the Ontario Doug Ford government that would take out bike lanes on three major Toronto streets. The Reducing Gridlock and Saving You Time Act was immediately challenged by a coalition of cycling activists once it was passed. The cyclists argue that removing bike lanes increases the risk of harm to cyclists and pedestrians, infringing on Section 7 of the Charter, which guarantees the right to life and security of person. The cyclists argue that bikers still need to use these routes, but will now be forced to do so in mixed traffic with cars, which is far less safe. The government has defended their position by emphasizing the economic and societal impacts of gridlock traffic and argues that this is a policy choice. While the case works its way through the courts, the cyclists asked for an injunction to stop the government from removing the bike lanes. The injunction was initially denied, but then the cyclists were ultimately successful in getting it. So for now, the bike lanes stay. What are we to make of all of this? Here today to discuss the case are two experts, Albert Koehl and Stephane Serafin. Thank you both so much for joining me today. First, let's talk about the underlying claim. The Cycling Coalition says that removing the bike lanes threatens their Section 7 Charter right to life and security of person. Albert, can you tell me why they say this?
Well, quite simply, the argument is that removing bike lanes means that cyclists' safety, their right to uh, life and security is being infringed. In other words, bike lanes make it safer to cycle. Without bike lanes, now they're going to be put in peril. And they're also saying that that deprivation is happening contrary to the principles of fundamental justice. In other words, this law is arbitrary, it's disproportionate. In other words, removing bike lanes really has very little to do, based on the evidence, about dealing with congestion. And so removing bike lanes and trying to connect it to the problem of congestion, which is a real problem, there's simply no strong connection based on the evidence.
Now, I do want to get to Section 7, and get Stephane's perspective on this. But before we do, maybe, Albert, you can paint a picture of what it is like to bike in Toronto. You know, I am a cyclist myself, and I actually use one of the very bike lanes that Ford wants to remove. So maybe you can explain what it is like for those people watching this who maybe don't live in Toronto, don't fight traffic on a bike.
Well, getting bike lanes has been a long fight. So I've personally been involved for almost 20 years getting bike lanes on Bloor Street in Danforth. And that's really one of the core routes. In other words, it's above the subway, it's flat, it gets you to a lot of places, including the university, stores, restaurants, and so on. So it's a very key bike lane, and now we've been connecting that to north-south routes. But ultimately, only 4% of city roads so far have bike lanes. So that means on 90% of roads, there are no bike lanes. And we know, for example, over the past year, when 6 cyclists were killed in the city, all of them were on roads without bike lanes. There was one exception where there was a bike lane in place, and that bike lane was actually blocked. So we know that roads that don't have bike lanes are dangerous. And we certainly appreciate, as cyclists, we appreciate the benefits of bike lanes, especially protected bike lanes.
Now, Stefan, I want to get your take on this. How do you think Section 7 might apply in this case, the Charter guarantee to life and security of person, if it applies at all? And how do those principles of fundamental justice that Albert referenced, how do those work in this case, if they do?
So, I mean, on a more abstract level, of course, people have a right to liberty, life, liberty, security of the person. The issue here is, well, it's really the principles of fundamental justice. And traditionally, what it meant was that the government was acting in a way that impinged on procedural fairness or some other substantive legal guarantee. There is no such real issue in this case. This is an issue of trade-offs. The government is prioritizing things other than bike lanes, and whether one thinks that bike lanes are a good idea or not. The claim fundamentally here is, yes, we're putting bike lanes in, and that may benefit some people, give them extra security, but other people are inconvenienced by this, or in fact, their right to life, liberty, security of the person may well be infringed by the decision to put in bike lanes. And so to make this into a Section 7 claim is, I would suggest, quite dubious for all of those reasons.
We've got to go to break now, but we will be right back. Back to Canadian Justice, where we're discussing a legal challenge to the Ford government's decision to take out bike lanes on 3 Toronto streets. A group of cycling activists have argued that this is a violation of their charter right to security of person. Now, Stephane, some critics of this claim have argued that this lawsuit is essentially a claim for what are called positive rights. Maybe can you explain what positive rights are and if you think this is an example of it or if it's a classic Section 7 claim?
So there's a distinction that can be drawn between negative and positive rights. So a negative right would be a right to non-interference. If you have a right to a house or an apartment, it could even be your lease. Um, it's usually a negative right. That means people can't just come in without your permission. Same thing with your right to bodily integrity. If somebody assaults you, they're infringing a negative right to non-interference. Positive rights are rights that correlate to duties on other people to do something actively for your benefit. So the claim here is fundamentally one that involves a claim to actively have the government install and maintain, once they're installed, bike lanes. And in this sense, it would be a positive rights claim. Now, just to be clear, positive rights, there's no problem. There's no inherent issue with positive rights. We have all sorts of positive rights given to us by legislation. The issue is that the government has finite resources, and as such, the question we should be asking is whether it's appropriate to have judges weighing in on the priorities that the government is going to choose to advance, or whether those priorities are best determined by the legislative branches and the government.
Albert, what's your take on this? Do you view this as a positive rights claim, which perhaps it's not a problem if it is a positive rights claim, but others have characterized this as once the government has undertaken the obligation to have roads and have cyclists on roads, they can't have the roads operate in a way that would violate the charter rights. So what's your take on if this is positive or a classic charter claim?
Yeah, Cycle Toronto in its application, I mean, it was quite clear that they're not asserting that this is a positive right. In other words, they're not saying that we have a right as residents to bike lanes to keep us safe. What they're saying is these bike lanes were in place. We know that they keep cyclists safe. In fact, the evidence says if you remove those bike lanes, the number of collisions will go up dramatically and the peril to cyclists will be increased. So they've made quite clear that they're not asserting a positive rights. That's yet to be determined by the court. However, what they are saying is that the bike lanes were in place. Removing them now does imperil their safety. There's increased risk of injury and death. And that's really the crux of the matter that the judge will have to decide.
Stefan, how does a court determine if something is a positive claim or not? Because that seems to be part of the big issue here. And I know that courts have opined on the existence of positive charter rights in the past. There's a famous case called Gosselin and Quebec, where the court said the charter has not been used to create positive rights at this point. So how do they decide if the argument is a positive rights claim or a negative rights claim? Because I think that might be really the core of how this might get decided.
So just to be clear here, yes, Gosselin theoretically says no, but the courts have kind of taken this logic of once the government assumes a positive duty voluntarily, you can't then take it away afterwards as a kind of workaround. We saw this in an Ontario Court of Appeal decision last year relating to climate change.
The Mather decision, yeah.
Yes, right. So what I would suggest is that when you're talking about a bike lanes dispute, the government not only has installed bike lanes, but there's an ongoing obligation to maintain them. If you're taking the position that they can't be removed, implicitly you're saying that those bike lanes have to be maintained, which implies positive duties, ongoing positive duties on the part of the government. maybe you're okay with this, but we should ask ourselves whether the government's entitled to change its priorities once it has chosen to install bike lanes. Perhaps those bike lanes will no longer be in the public interest. Perhaps the government has different priorities. Perhaps the electorate has conveyed to the government that it should have different priorities. So the logic at play here is one where once the government says we have bike lanes and we install them, it would be forever bound to keep those bike lanes in place and to maintain them. And I would suggest that that is the core of a positive obligation.
Albert, is there anything you want to say in response in the last 20 seconds?
Well, simply that the evidence is clear that these removing bike lanes will make it more dangerous. Will make the roads more dangerous for cyclists. Will expose them to greater risk of being hit by cars, and that collisions will go up significantly.
We've got to go to break. Welcome back to Canadian Justice, where we're discussing a decision by the Ford Ontario government to remove bike lanes on 3 major roads in the city, and the response of a lawsuit by a group of cycling activists who argue that removing the bike lanes would put them at risk of collisions, violating their charter right to life and security of person. Now, while we're awaiting the outcome on the merits of that case, we're waiting for a court to determine if the rights of these cyclists would be unjustifiably violated. In the meantime, the cycling advocates have asked for a court injunction to prevent the government from taking out the bike lanes. So, Albert, what has happened in that case? And maybe first you can tell us what an injunction is and what the test for it is.
Yeah, so simply what Cycle Toronto was asking for was that while we wait for the case to be argued and then subsequently for the case to be decided, we want to prevent the province from taking out those bike lanes. In other words, they're asking for an injunction, and the test for an injunction is threefold. First, is there a serious issue? Would there be irreparable harm to cyclists? And 3, what is the balance of inconvenience? In other words, is there greater harm to the government or greater harm to the cycling advocates? There wasn't really much issue about the fact that there is a serious issue to be tried. In other words, the Section 7 claim. Secondly, that there would be irreparable harm to cyclists, given the evidence about the safety implications. And really what the original judge did on March the 11th, when Cycle Toronto asked for an injunction between March the 11th and April 16, which is the date on which the actual hearing took place. They asked for that injunction, and initially the injunction was denied, and it was based on that third prong. The judge decided that the balance of inconvenience really favored the province. Subsequently, then, when the case was actually argued, the Section 7 application was argued on April 16, the judge returned to that question, should I issue an injunction between April 16 and whenever my decision comes out? So the court on that date reached a different decision, and there was no doubt that the court was certainly unimpressed by the fact that the province a month earlier had said we really need this to take out the bike lanes and deny the injunction, spent an entire day in our overburdened court system arguing this case, and then did nothing. So when the case was then, the injunction was reviewed again, the court made clear that even though the province was saying, well, when we put in place a law, there's a presumption that we're acting in the public interest. Well, the court made it quite clear. Justice Chabas said, well, there are competing public interests. So looked at the fact of this contrived urgency to take out bike lanes when you hadn't taken out bike lanes when you had the opportunity, said really weighing the factors, it's more of a serious issue than we had thought initially, and the irreparable harm is greater, so we're going to put a bit more weight on that. There are other competing interests, in other words, trying to keep our roads safe and building a cycling network. So reviewing all of those factors, the court came to the conclusion that we're going to issue an injunction until my decision comes out, which could be in a month or two.
Interesting. So it was heard twice. The first time it was granted because the government had made this case of urgency on the balance of convenience branch of the injunction test. Then the province actually didn't act urgently and remove the bike lanes. So that weighed against them when it was considered again. the second time as part of the broader hearing. Stephane, what do you think of the reasoning on the injunction in this case? Do you think the test was met? What do you think of the court responding the way it did when the government failed to remove the bike lanes after they claimed that urgency?
Well, with all due respect, it's a pretty shallow decision, and I'm a bit concerned that the court appears to reassess the competing interests at play here and kind of substitute its own vision of what the public interest means over that of the government. Um, there's a fundamental structural problem with these cases, which is that the only interests actually present in court are going to be those of the plaintiffs, and the government kind of standing in for everybody else who could be affected by this. Now, the government has limited resources, has a limited ability to actually defend these cases. And so there's a number of individuals in the broader community whose interests will not be represented. And I don't see their interests really represented in this decision. Whether that's the fault of the judge or the parties, I'm not sure. I'm not going to weigh in on that. But it's just not there. What we have fundamentally is a claim that the public interest might require bike lanes.
Hmm.
And that is weighed against the public interest as the government presents it. And that's it.
Yeah, really interesting. We've got to go to break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a legal battle over bike lanes. A group of cycling activists obtained an injunction to stop the Ford government from removing bike lanes on three major Toronto roads. Now, once this decision came out, I think we all know what Doug Ford thinks of it, what he thinks of the injunction. After it was granted, the premier claimed that Canada's, to quote him, politically appointed judiciary is overstepping its authority, and that judges should be elected so that they are more responsive to the will of the people. Stephane, what is your take on Ford's comments?
So I kind of understand Premier Ford's frustrations here. There's a structural problem with the Canadian Constitution in that Superior Court judges are appointed by the federal government, and the provinces afterwards are kind of left holding the bag for both funding the justice system and also implementing concrete policies, like, for example, installing bike lanes. So there's kind of an issue where the people who are closest to the action are not actually having a say in how the judges are appointed. That said, I think that elected judges is probably not the way to go to resolve
It
this.
seems like the
I'm
attorney
more
general
partial.
agrees. I think the attorney general clarified that we're not going to be doing that.
Well, I mean, it would require some kind of constitutional amendment probably to do. And that said, I'm more partial to Quebec's solution, which is to propose a list of judges to the federal government to then nominate off of that list. Kind of informal cooperation between the provinces is the easiest fix to this problem.
And I actually think Ontario has recently proposed legislation, if I'm not mistaken, that would change how judges do get appointed. Is there anything you can add there, Stephane? Or I don't know if you're tracking that issue.
Is this for provincial court judges or superior court judges?
I
'Cause
uh,
I'm
I
not.
shouldn't have asked because now I forget the the legislation.
So I'm not aware of anything for superior court judges, but I would be very interested to know how they've been handling that.
Yeah, I understand that there is a proposed change to how appointments are going to be working, but it's still in bill form. Albert, anything that you can add to Ford's comments? What was your take on Ford's reaction to the injunction?
Well, the first thing I thought is this is exactly what we'd expect Donald Trump to be saying. I mean, what Ford was really saying is when I don't like a decision, then those judges aren't making the right decision. So I think as lawyers and anyone that's watching the system should be really concerned because the whole purpose of having a judiciary and independent judiciary is that we're not at the whim of political decision making. So this really should concern us. And throughout this process, and I think the context has been really important, this is really we're dealing with a bike lane that Doug Ford doesn't like. And because of that, he's put in place this Bill 212. And then once Bill 212 was announced at a place called the Crooked Q in the Kingsway, this was the minister at a local establishment announcing Bill 212 and saying, we're not planning to take out any bike lanes, and we may do that if the evidence shows it. Then the premier came in and said, we're taking out bike lanes on Bloor University and Yonge Street.
Which is
And there
right
was no
where Crooked Q is located.
That's where Crooked Q is located, and also happens to be sort of the route that the premier would take from his home in Etobicoke to Queen's Park. So when we're talking about arbitrariness and sort of the whim of the premier, we should all be concerned when he's making a rule for the entire province because he was upset about a particular bike lane in Etobicoke where he lives. And that should concern all of us, and it should concern us that we've got a premier sounding very much like Donald Trump, saying that if I don't agree with what if the judiciary doesn't implement my will, then that's a problem. And saying things like I'm going to pay judges that are bleeding heart judges, that as he terms them, then I'm going to pay them to retire early. I think all of us should be concerned about that because those are the kinds of balances and those sort of protections that we have as citizens that protect us from a government that's really just trying to do something which is beyond the law. And in fact, the key issue here was that this law, and we know it had nothing to do with congestion and everything to do with the premier's whim. And that should concern all of us.
Albert, just very briefly before you finish, the Section 7 claim's been heard. When might we have a decision in that case?
Well, in terms of the Section 7 application, we'd expect it in, perhaps in a period of 2 months. I mean, these are complex issues that the judge is going to have to deal with.
That's all the time we have. Thank you both so much. We've heard today about the legal battle over bike lanes. And while I bike and I enjoy the bike lanes in my neighborhood, I'm not convinced that their absence would violate my constitutional rights. And I'm concerned that this case does bring us into the realm of positive entitlements. But what do you think? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.